All right, the key players and legal basics in trusts. So basically, there's three main key players in every trust, whether it's a land trust, irrevocable trust, or revocable trust, spendthrift trust, bulletproof trust, common law trust. They all have the same basic framework. So just know that. So first, you have the granateur. Granateur is also called the settler or creator. If you have my company build your trust, we'd be the creator or the settler, and we'd grant it to you. And you'd also have your LLC be the beneficiary. So basically, the grantor is the person who makes the trust and deeds the real estate into it. Okay? In almost every land trust, the grantor starts out as the same person as the beneficiary. However, you want your LLC to be the beneficiary for liability protection. The grantor can almost always revoke the trust, amend it, or add or remove property. Or you can change who the beneficiaries are. That's a cool thing. So if you have a buyer and you want to sell the property to a new buyer, you can change the beneficial interest to the new buyer. And then he doesn't have to record a new deed and go to title unless he really wants to. And he really wants to go to closing and spend all that money for closing. But you can educate your buyer how you can just change the beneficial interest to him or his LLC. So anyways, the trustee. The trustee is the only name that shows up on recorded deed in the public records at the county level. So if you sign these as a trustee at the title company, your name is going to show up in public record. It's going to show up in Lexis and in the credit bureau data. And I will talk about that in a different video. So basically, in a true privacy and land trust, the trustee has virtually no power at all. The job is to simply hold legal title, and do whatever the beneficiary tells them to do in writing. People often use a friend, their attorney, or a title company or bank department. Just know that a title company or bank is not going to do this unless they really know you really well. So that's where you got to get a friend involved or maybe an attorney to be your trustee. I often advise that you just pay a friend or maybe one of your team members to pay him like $100 to $500 to sign paperwork. He's going to sign paperwork to be your trustee, your interim trustee. And then once you're done recording all this and signing paperwork, you're going to fire him as your trustee. You're going to say, hey, you're no longer involved in this deal, unless of course he's involved in the deal and you want him to stay there. But you might want to take him on as trustee anyways, just so he doesn't think he has some like equity interest or something. Equitable interest. Anyways, that's just my advice. But you can hire and fire a trustee. So people often use their friend or attorney, and you can name yourself as trustee, but then your name will appear in public record, and you will lose the benefit of privacy. All right, just know that. So the beneficiary is a person or LLC that gets all the real benefits. That the income tax, the tax deductions, the right to live in the real property, sell it, or refinance it, or rent it out. And obviously the LLC can't live there, but you can rent it from the LLC and live there yourself. Or you can rent it and stuff like that. So the beneficiary has the power of direction written into the trust agreement. That single clause forces the trustee to follow the beneficiary's orders about the property. The beneficial interest is treated as personal property, not real estate. Which is why you can sell or give away or transfer the beneficial interest to a new buyer without recording a new deed. So just know that. So if you have a buyer and you want to sell this property, you want to sell your deal to a new buyer, you can educate him and tell him you can just transfer the beneficial interest to him or his LLC. And then he has it. He doesn't have to go to title, doesn't have to pay for closing, and all that stuff. And of course, if he doesn't believe you, you can book a call with me or hire an attorney, and you can educate him. Anyways, moving on. So we have revocable and irrevocable trusts. So revocable trusts, this is what 99% of land trusts and living trusts are. So a living trust is basically a will. That's all it is. It's basically a living will. A living trust or wills have no asset protection in it. There's no asset protection. There's nothing protecting you or your assets. So just know that. You can change your mind anytime, add property, take it out, change beneficiaries, terminate the whole trust. You know, that's the main thing. You can change things in revocable trusts. Banks love these because they can implement these trusts, give them to you, and basically they're the grantor and they can revoke it or change things all the time. So you keep total control. There is no gift tax when you fund it, and you continue using your social security number. But I would suggest you get an EIN from the IRS. Get your EIN, especially if you have team members involved in this, maybe some partners involved. You want to get an EIN for the taxes and stuff like that. The downside is that there is zero creditor protection while you're alive, because the law still considers it your property, unless you're using a LLC as your beneficiary. All right, so we have irrevocable trust. This is what I love. I use irrevocable trust in just about everything I do. I love it because the banks can't change it on me. I love it. So, irrevocable trust. Once you create it and fund it, you generally cannot take it back or change it. That's the general rule. There are ways to, add things, make amendments, but you really can't change it. This gives you real estate, real asset protection, and possibly estate tax savings. But the banks hate them and they won't lend to them. You often have to pay transfer taxes when you're deeded with property in. And the trust itself gets taxed. So if there's ever a sale on the property, it's going to get taxed through the trust. And almost no real estate investors use irrevocable trust, as simple land trusts for real estate flips and rentals work better. However, if you're going to keep the property, I would suggest you do an irrevocable trust. It actually works a lot better, provides you asset protection, and gives you a lot of tax benefits and stuff like that. If you're just going to keep the property or use it as a rental, then yeah, you can use a revocable land trust. So land trusts are deliberately written as revocable grantor trusts, so the IRS completely ignores them and they consider it your property. You keep reporting the income and deductions on your personal 1040. They're just going to roll up to your 1040 tax return. And exactly as if you held title in your own name. However, you get the benefit of the land trust. So there are a few state-by-state differences, and that's why it's good always to check your state laws. But not every state recognizes or honors the classic land trust the same way. Some states love them, and everything works exactly as advertised. So like Florida, Illinois, Virginia, Indiana, Arizona, Ohio, Hawaii, and North Dakota are the friendliest land trust states. However, every state has to honor a trust because they're held up by Supreme Court law and Supreme Court case law. There's tons of case law that supports trusts and the use of trusts in every state. So every state does honor trusts and land trusts. Like I said, it's held up by state law. Supreme Court law. So you're good in every state. Just some states don't like them as much as others do. And you have to know there are some states that have transfer taxes, documentary stamps, county recordings, homestead exemptions, property tax caps, mortgage due on sale clauses, and foreclosure rules can all behave differently depending on where the property is located and depending on the mortgage company you have. So just know that. So the bottom line takeaway, in a land trust, the grantor and beneficiary are almost the same person or the person's LLC. And the trustee is on public record. So just know that. I'll talk more about that later in a different video. The trustee is basically a placeholder who must follow the beneficiary's direction. Land trusts are kept revocable on purpose so you can retain control, simplicity, and identical tax treatment as you're basically 1040 reporting. So using a tax plus an LLC always is better than using your own name in deals. So just remember that. See you in the next video.